What termination types does the ban cover? Like many other countries around the world, Turkey has also taken a number of economic measures. One of these measures was to limit the employer's ability to terminate employees as per Law No. 4857, Temporary Clause 10, in April. The prohibition of termination is valid from the date Law No. 7244 was enacted, which is 17th of April 2020, and will be effective for 3 months from this date on during the pandemic. This period can, of course, be extended by the government for up to 6 months. If employers terminate employees against the rules of the ban between 17th of April and 17th of July 2020, they will be fined to the amount of the monthly minimum wage per employee. Additionally, workplaces that are working under short-term work conditions will not be permitted to terminate employees for the whole duration of the short-term work condition. An employment contract can be terminated by an employer or employee. There are also situations where the employment contract will come to its natural end. There can be many reasons for terminations. So, which employment reasons have been affected by the ban? This is a topic that has made employers hesitate. The scope of the ban has been clarified by international correspondence between the Turkish employment and unemployment offices. One of them is termination by the employer during the probation period, which is reported to the Social Security institution under Code 1. The probation period can be a maximum of 2 months from the start of the employment contract. During this period, the employee or employer can terminate the employment contract without providing any reason. However, the employer cannot terminate the employee during the 2-month trial period while the prohibition of termination continues. Employees can terminate the contract during the trial period if they wish. Another termination reason that has been banned is the termination called for termination of a permanent employment contract by the employer without a justifying reason. Employers are also not able to terminate employees under justifiable reasons either, such as constant punctuality issues, performance issues, etc. Collective employee terminations, which is declared to the SSI office under Code 15, is another termination reason that is not allowed during the ban. Employers will also not be able to terminate employees under Code 22. Other reasons that is commonly used when a mutual agreement is made between the employer and the employee. One of the terminations we will discuss within the scope of Law No. 4857, Article 25, immediate terminations for justifiable reasons. Under this, the employment contract cannot be terminated by the employer for health or compelling reasons and imprisonment. However, it is important to note that termination reasons where cases that do not comply with rules of morality and goodwill and the like will be excluded from the ban. Employers may terminate employment contracts due to the reasons listed under this title while the prohibition of termination continues.